therefore, you ask, and if they can give you no reasonable excuse, then you record. If they just say no, we use their rules and say, give me a reasoned explanation of why you're denying me the right to defend myself. So with this knowledge, we can start to force the court, okay, it's called moving the court to do the right thing. Most people don't realize when you put in an application to the court, you put in the result that you want, the order, okay? So I want to apply for disclosure, and here's the order. Within 24 days, or 18 days, or 16 days, or so many hours, I want this action taken, I want the court to rubber stamp the order. Okay? So what happens with council tax? They haven't paid, give me a liability order please, mate. If you don't stand on your rights, you end up with a default judgment. And we'll look at default judgment because it's important for people to understand that. Okay? If you don't ask, you don't get. If you ask the wrong questions, you get the wrong answers. So we need to take responsibility for this.
You don't said no sketches, Mark. How did they get away with showing? I mean, I don't watch the news now, but they always used to show sketches of people in the court.
But at the time, it made rational sense. Court reporters are meant to be trained to distinguish between what was factually evident in the court and what is opinion, and therefore they've got some leniency, and in the courts you'll actually have a space for court reporters. Okay? Okay, Randolph, if you can forward me a copy of those FOIs,
Yeah.
and then the next step is then, how do we force the record? Okay, because this is important in Calvin's case. We need to force the record.
Yeah.
If there are courts of record, we need an official transcript of it to prove that they acted unlawfully. That's it, end of story then. All of this crap goes. Okay? So if you could email me that, that would be great. Okay, so basically at the moment, my understanding is magistrates' courts are not court of records in the context that you cannot get a full transcript of every word that was said. Randolph is going to sort that one out for us. Other courts are courts of record, but however, what's important with this stuff is, let's look at the basics of the law. Common law precedent is the judicial system we operate under. Supreme Court is live streamed. Appeal court is live streamed. Both of them have a free service where you can watch everything that went on. Is that not a precedent that the lower courts must follow? So therefore, if the Supreme Court can live stream, why can't I, via my Facebook account, live stream? I don't know. Nobody's asked the question. Okay? So these are things that we're starting to challenge. Okay, so what I think we'll do is we'll just, how much we got? 10 minutes, cool. Okay, into your heads, drum it in. Contempt of court is what?
Anything that biases any party.
Thank you. Anything that prejudices a party, end of, that's it. Okay? So the test for contempt of court is, was the act intended? Was it calculated to interfere with the course of justice? And was it capable of having that effect? So that is what's called the charging standard. To prove a contempt of court, that's all that you need to prove.
You have to prove it was calculated.
Who's the appellant, by the way?
Okay, if you're accusing me of contempt of court, okay, I'm appealing the contempt, so I require you to prove that my action was knowing with the intent that it was calculated to interfere with the due course of justice, and was it capable of having that outcome? Basically, if I'm the court and I'm holding you in contempt, all right, you are appealing it. These are the things that need to be proved for the contempt to be upheld. Okay, so basically, when the judge says, all rise, and you don't stand, I'm holding you in contempt of court. Who's it prejudicing? Nobody. You know, where is it interfering with the due course of justice? Nowhere. If you wear sunglasses or a hat or come in pinkish clothes or whatever you do, how is that prejudicing any party? It isn't. But what you're doing is hitting their ego. Okay? I'm the boss and you must do what I tell you. And if you don't, well, don't do it, I'm going to hold you in contempt and I'm going to threaten you with violence and drag you down into the, you know, whatever, blah, blah, blah. Okay? So, with this, they always try and shut you down on contempt charges. So quite simply, if they threaten you with contempt, just say, show me how this action is prejudicing. And
Surely that threat alone is biased.
correct. Absolutely.
But
Okay.
what would you do when the security guards are sort of there dragging you off?
Well, you got at the end of the day, okay, you need to remember the only thing that they rely on,
Violence.
threat of violence backed up by actual violence.
Yeah.
That is it. They've got no more. That's it. That's what the whole system is based on. Fear. End of.
That's what he's talking about.
Okay? So basically, you make the choice: do I want to go down and sit downstairs for a few hours, or don't I?
Well, I did.
So they would make the claim that me, the appellant, is interfering with the course of justice, and I would then say to them, prove that what you're doing is justice.
Yeah.
Okay.
Okay. So, sort of examples of contempt: if you try and interfere with jurors, if you shout abuse at the judge or throw things at them. So these are actual case law, okay, so those sort of things. But fundamentally, it is just the interference with the due course of justice which prejudices a party.
There's two, is it criminal and civil as well?
Yeah, I mean, I'm not... Look, all of these contempts are basically designed... okay, the fundamental, the substance is, does it prejudice?
Right.
Okay, and then the next thing is basically how can we enforce our will? So civil and criminal basically is whatever they decide in their legislation.
Right.
But at the end of the day, okay, so for instance, there's when you look at there's loads of videos that go around on YouTube where basically common law wins. Okay, judge walks out. Abandon ship, all this stuff. Okay, if you actually listen to those, what's happening is, and in many of them, if you listen to what's being said, the judge actually says, I'm adjourning, and the reason he's adjourning is the judge doesn't want to lose his temper, because my God, imagine that will make the news, okay? And so what the judge is saying, look, I'm fed up with this stupid Freeman of the land crap, or I'm representing this piece of paper, or all of this nonsense. And the judge is like, and so rather than losing their temper, what they're saying is, right, matter adjourned. Let me go and have a cup of tea, calm down, relax, and then I'll come back and try again. Okay? And so what they do is they do give ample opportunity for people to explain their side of the story. And certainly on the civil side, it is much more fair and just when you get out of the magistrates' courts. But with the magistrates' courts, what they do is, because the vast majority of cases are dealt with in the magistrates' courts, and this is why I believe that they don't make available records, which hopefully we can change, okay? Is that people don't get to learn and see what is going on there. And so with recording and stuff like that, what they're saying is, hey, listen, because I told you you can't, you can't. And if you don't listen to me, I will hold you in contempt of court. But because we don't understand the substance of a contempt of court by simply turning around and saying, up yours, okay, I'm the only one that can be prejudiced, I'm quite happy for it to be recorded, and you've not shown reasonable grounds. Therefore, you've got absolutely no reason to hold me in contempt at all. It's used to threaten and coerce, okay, and that there is not right.
As soon as I get rid of these warrants, I'm going to test that one.
Oh God, we get, this stuff we're starting with everything. Yeah. No, no, definitely.
Here's the thing in my one.
Yeah.
A magistrate court is a court of record, so they say.
So give me the record.
Right. I went down to the court because they weren't answering me, the CPS, the London magistrates, the Westminster.
The whole lot. Because
So,
they don't know the rules.
One guy came back and he said to me, I can't find your case in the court records.
Yeah.
So I physically went down to the actual court and asked them. They can't find my case in the legal court record.
Therefore,
So
it's
I
not
said,
a matter before the
So
court.
where is my case then? Oh, you would have to go and see the CPS. So I said, hold on a minute.
You've
I'm
summoned me
aware,
to the court.
yeah, I'm aware that the CPS is the claimant. So are you telling me the claimant is administering the case, which would be a conflict of interest?
Yeah.
Oh, I can't answer any of these
Yeah, yeah.
questions.
Yeah, and this is one problem when people are phoning, for instance, the courts and stuff like that. Okay, what you're doing is you're getting somebody that actually has no idea what they're talking about.
Yeah.
And through leading questions, you're getting them to go where you want. Okay, and so it's got to be very carefully dealt with, this sort of stuff.
It's like we were moving into Rennie Court.
Oh,
we
God.
were moving into Rennie Court.
Yeah.
I know it was an absolute joke. And then they gave us the email address, we submitted everything through the
And
email
still
address.
nothing.
Now they've said that it's gone to their legal team, and I've challenged them on the fact that, I'm still waiting for my information to come back from their legal team. All this, like Mark said, I'm going to be very patient. I'm not pushing anything, I'm just riding away. Because believe me, by the end of it, when we actually hold them accountable, which we will,
We've got all the evidence.
I've got all the evidence of the fact that all these people have just blatantly ignored me. You know what I mean? I've complained to them, I've done everything I need to do.
We've even got their own internal documents as to their job. We've copied them back their own documents. Okay? And they still have no idea what we're talking
Yeah,
about.
they just said it's their legal team.
I-
That's all they've got. Now, I know, don't get me wrong, I know that, there's so many cases going to the courts at the moment that they're actually inundated. Hence the reason why we're all sitting, waiting, it's all a waiting game. And that's why I'm not pushing as hard as I normally would. But again, I just want them to keep making the mistakes.
Yeah.
So that then I can just cash in on the fact that they've made the mistakes.
The record.
Yeah.
Exactly.
And one thing I can tell you, okay, from Michael Benicio, I had to learn patience, right? This is a game of chess. So council tax, they know they're checkmated. With what we're doing with these fundamental rights, they know they're checkmated, okay? Because with the council tax, what we're doing is we're standing up on fundamental principles of law. They cannot rebut it, they know it, okay? Now, what's interesting, after I brought out the Peacekeeper course, with that, in February 2019, so this was before we brought out the knock-knock council tax challenge, Boris Johnson actually turned around and said, and made a public announcement, we are going to pick and choose which judgments we abide by. What is that about? Oh, public notice, guys.
Yeah.
Okay? I'm telling you in public. All right? But more significant, it means we've won the spiritual war and we've won the intellectual war. Now we're just manifesting into the material. After the knock-knock process, shortly after that came out, what did they say? They made a public announcement. We need to look again how we do local government financing. They already knew with version 1 that they were doing. Okay? So again, right? But it's all about a game. But there's serious consequences with this game. And so they know they're checkmated. But it could be 3 moves, 5 moves, 7 moves, who knows? Okay? So we need to be patient step by step, and what Dwayne's described is, I can guarantee you, and Calvin can stand vouch for this, they will dig a hole so bloody deep,
Yeah.
and through their ego, they will hang themselves, okay? Rather than putting their hands up and say, shit, sorry, I made a mistake, okay? So it's about patience, and using leading questions and leading them to gather the evidence that you need to get a successful prosecution.
Because I mean, the evidence that we've gathered, obviously, as with anybody who does this, we've been very meticulous, and I mean, he's obviously helped me at Chicago. We've been meticulous in gathering that evidence. And we've got everything that proves contrary to what they were claiming over the last 2 years, which obviously would be detrimental to them if we were to go to court. You know what I mean? So that's the reason why they obviously, I can guarantee you somebody's read it and gone, holy crap, you know what I mean?
Yeah,
Because
and
if they rule for me, you know what I mean, or if they said they rule against me, then we appeal it. Then they'll trap themselves even more.
Yeah.
Because if it goes to appeal court and we win, you know
Yeah,
what I mean?
Then it gets much more serious.
Then does it? You know what I mean?
There's a bit higher up said examples of this type of contemporary disobedience of the court.
yeah, that's them basically trying to impose their will, you know, wear a hat or don't wear a hat or dress like this or dress like that. But basically the important point is, if there's a contempt of court, there's an automatic right of appeal. There needs to be an independent judge that was not involved, okay, and that needs to be appealed. So in the manual it tells you how to appeal the contempts of court.
In court, sorry,
Yep,
in court, magistrate's court, Toby, you know Toby,
yeah.
okay, he
He was a plonker.
yeah, I know he was a plonker,
What good is he down in the cells on points of principle?
yeah, but it was, did we have as an audience the right to then voice our
Of course you have, you're the policeman.
because I've done that in court, in another magistrate's court, I've voiced my disapproval of something, and I was told by the magistrates that if I didn't shut up, I would be thrown out and held in contempt of court.
Right, quite simply, I have the right to inquire in every matter to ensure your actions were lawful, Mr. Magistrate. And from what I've witnessed, your actions were unlawful, and therefore you have no right to proceed until this dispute is settled.
And who am I prejudicing?
Okay, I want to finish off then on another big challenge that we're putting in, basically this one of representation. Okay, so in essence, basically the SRA and BAR have a monopoly on legal representation. Again, let's look at the substance behind it so that we understand the intent. Okay, what's happened is law has become specialized in many areas, as we'll see tomorrow when we look at the actual structure of courts. And the idea of the specialization is to make efficient use of time so that you don't need to reinvent the wheel every time. Okay, i.e. when I say reinvent the wheel, re-educate in this particular law. So for instance, you've got divorce law, you've got family law, you've got intellectual property law, you've got trust law, you've got admiralty law, you've got, you know, shitloads of different types of law. So if we kept into generalities, it's fine because you can apply the principles to everything. But there become certain technicalities in the speciality, okay? The way certain things have been resolved in that. So rather than re-educating, every time we go into a hearing, the judge and the, you know, even the legal professionals, the solicitors and that, okay, that's a waste of public resources. So there's nothing wrong with specialization itself, so long as it's applied properly. Okay, so what they're saying is, in essence, with representation, because of this specialization, okay, we, on behalf of the people, are going to grant a privilege to certain people to practice law and uphold the rule of law. Okay, and therefore, they grant this special right to solicitors and barristers. However, because we don't understand what the rights and obligations are to us for that privilege that society has granted them, they do what they like, which is as little as possible for their own personal interest. Okay, this is what Adam Smith calls the invisible hand, self-interest. So, like I said earlier, briefly, it's the conflict of interest. We are interested in conflict resolution. Okay, they wouldn't make any money if they resolved conflict quickly. So that's the conflict of interest. So by understanding their duties, rights and obligations to us and to society, we can start to hold them to account. So firstly, obviously it's unlawful, and I've mentioned the Statute of Monopolies before, Statute of Monopolies 1623. Why is it unlawful? Okay, basically because all are equal under the law, nobody is above the law. I should have the right to choose how I best defend myself, and I know my best interest. Okay, so what they're doing is they actually are denying you the rights, okay, to defend yourself. So essentially, this is a hot debate, and it's regularly discussed in there. And they recognize that more and more people are dissatisfied with professional representation, and more people are actually starting to do it themselves because they realize they're just wasting their money on these professionals. Okay? Now, with them saying that, sorry, you can only be represented by our approved list, what they're doing is they're tying one hand behind your back. And what's your probability of winning a case or losing a case? 50-50. So you're tying one hand behind my back and saying, you know, pick one of our dudes and you've got a best chance 50% of winning it. I mean, what sort of odds are that? It's ridiculous. However, it's actually a contempt of court because it's prejudicing you. Okay? Therefore, you should be allowed to have whoever assist you however you want them to assist you. Okay, so we're putting in powers of attorney and we've had varying success with them, with rights of audience. So far it's just under 50%. Okay, now what we're doing with it is we are delegating because I'm the creator, I have my authority, and I can give it to whoever I want. Okay, and ask you to act as my agent. And so long as you do what I've authorized you to do, I've carried the can. Okay? So what we're doing with these is the court is avoiding dealing with the substance. Why? Because we're directly challenging the Bar Association and the SRA, the monopoly on it. Okay? So what they're doing is sidestepping it, and they'll always grant us Mackenzie Friend, and sometimes they'll grant Mackenzie Friend with rights of audience, and twice now in criminal matters I've been granted including rights to cross-examine the witnesses. Okay? And where they're refusing it, we're putting in a section 111, we'll talk about it tomorrow because that's a really powerful tool to start to hold them to account. We're getting to the point where we are asking them to put in writing why they do or don't do what they want. So representation is a massive thing that's challenging the establishment, which what you were saying, okay, do I feel threatened? No, I don't feel threatened. You know, it's all out there. Anybody can do it. So there's a power of attorney, a general power of attorney, where we basically say that if you deny me the right to choose my representation, you're in contempt of court, is what it is. Okay? So that's an example of a power of attorney. And that's where I want to stop today. So, anybody got any questions?
Yes.
Yeah.
Simon Dolan,
Yeah.
how does one get to ask the courts why E was not listed?
Right. Now, with that, okay, I've read somewhere, but I can't bloody find it again. Okay? It's there. That we have the right to intervene in any matter. And therefore, we can intervene with that judgment and ask them for an explanation. Where the foundation is, I mean, where the precedent is, I just can't find it at the moment. But yes, that is how we will do it. Okay? But again, it's obvious in substance. We know there's an error and we require them to correct it. So we have a choice. We can appeal it in their system, okay, or we can find a way around it. And that's what Dwayne is working on. So we're trying to, all of these things should be addressable in the magistrates' courts, free or pretty close to free. However, what they're doing is with their rules, forcing things, magistrates can only deal with this, county court can only deal with that, high court can only deal with that, appeal court and Supreme Court, okay? And guess what? The costs just go up. So they are in breach of common law equality and fairness in where we can have access to justice. So by the court following Parliament's will, okay, that actually is a contempt of court. Therefore, them asking for charges is a contempt of court. Okay? Calvin, did you end up paying for the appeal?
No,
No. Right? Why?
I don't see why I should.
Correct.
Like I told him, if your fucking judge can strike it out with a bit of paper, why can't I put it back in with a bit of paper?
Correct.
We're all
Okay.
equal under the law.
Exactly that. Okay? So once we start standing on our rights, we fucking get our rights. Okay? So much what Calvin's done and expressed in there is up yours, mate. I don't, you've got no right to do it like this. So we will find ways through it, and in theory, everything should be addressed in the magistrates' courts.
Isn't under I can't remember if it's a Bill of Rights or anything, isn't it? They said you can't sell justice.
Yeah, that's I think the privilege, 1500 Act, whatever, is the one that references it. There's Magna Carta, then there's
Yeah.
the privilege of the subject or liberty, whatever, I can't remember. The 1500 Act is you do not sell justice or deny it or whatever. Okay, anything else yet?
Yes, might foreseeably have seen wages. That is,
It is just so open. Okay? But everything comes back to a reasonable decision. Explain how you reached that conclusion that it was reasonably foreseeable. But in essence, what the substance of what it's trying to get behind, have you applied your mind to the consequences of your actions? Okay? As opposed to have you just gone out and done something really stupid. That's the substance behind, or the concept behind that due diligence, in essence, is what it's saying. If you cannot show you followed due diligence, it's reasonably foreseeable that harm would have come from your actions.
i.e., in the 90%, it is believed that there is virus contamination, or whatever it is. 90%.
No, that there is very different, because that's easily evidenceable, provable.
No, but their action is that my going against the mask rule and all of that, okay, I can be accused of, you could foreseeably see that you were in danger of infecting the whole population.
But first, to be able to do that, you need to prove
They have to prove the effectiveness
that
of a mask.
it is infectious,
And
or that it even exists. Because
Yeah,
if
yeah,
they
yeah.
can't even show that it exists,
No, but
because guess what? hearsay evidence is not admissible. We'll be talking about this tomorrow.
Yeah,
Why
yeah.
does 90% believe it? Oh, I saw it on TV.
Yeah.
That's hearsay evidence, not admissible. Out.
No, but it is their justification for
It's
getting
no
rid.
justification. That is no justification. It will not stand up in court.
See, this is
Under
this
their
is the
own
problem.
rules.
Everything comes
It's
from
hearsay
authority.
evidence.
You know, and that's the problem with a lot of us, is that we're all brought up from life, from a young age, looking at authority, aren't we?
Yep.
School, principles, all that bollocks. And now all of a sudden we get into real life where we think, I thought I was free. And you start asking questions. Like, I always ask questions at school. I always got caned for it, yeah? So I'm getting caned in life as well. I don't give a toss, I'm still asking questions. I don't care. Who's going to stop me from asking a question? If it's wrong, it's wrong. That's it, end of story. That's where your moral, you suppose your moral compass comes in, eh? Where they can lie, let them lie, but the truth will always, show its face. Because, 2 years ago, there's no way you would have thought, the way they were treating us, like we were all criminals,
Yeah.
you know what I mean, for not wearing a mask. Are you kidding me? I wasn't wearing a mask and you treated me like a criminal. I didn't sign a piece of paper on an airplane. You treated me like a criminal. You shut my business down. People committed suicide. The collateral damage to what they've done is disgusting. And now they want an amnesty, man. Oh, sorry, pardon my French, but fuck right off, man. They ain't getting no fucking amnesty for the amnesty they got is just fucking real.